We often talk about how slowly things move in Washington, right? Laws taking years, regulations stuck.
Absolutely. The wheels can grind incredibly slowly.
But what happens when it goes the other way? Like lightning fast. Imagine a huge policy targeting a major player getting completely flipped in just 1 week.
Yeah, that kind of reversal at the highest level, that's almost unheard of. It signals something pretty dramatic must have happened behind the scenes. Intense pressure, big concessions.
And that's exactly what we're diving into today. We're looking at 2 executive orders from March 2025, back to back, all focused on one of the biggest law firms out there, Paul Weiss.
Paul Weiss, Rifkind, Wharton Garrison LLP, a giant in the legal world.
Right, we've got the actual documents from the Federal Register, first, EO 14237, the one that brought the hammer down, then EO 14244, just 7 days later, that basically said, okay, never mind.
And our mission here is to unpack why. What leverage was used? What did Paul Weiss have to agree to make this whole thing go away so quickly?
Because this isn't just, a legal curiosity. For you listening, this could be a real case study in how government power can directly impact corporate policy, like internal corporate policy.
Exactly. It touches on hiring, political activity, the works, especially if you're in any large professional services firm that deals with the government. This is potentially quite relevant.
Okay, so let's set the scene. March 14th, 2025, the first order drops, EO 14237, and the justification, well, it's broad. It claims global law firms have played an outsized role in undermining the judicial process and the destruction of bedrock American principles.
That's incredibly strong language. You don't usually see that kind of direct accusation from the White House aimed at a specific company.
Not usually, no.
Yeah.
So to back that up, they had to list specific complaints, right? What exactly did they say Paul Weiss did?
They zeroed in on 3 main things, basically building a case across different aspects of the firm's operations and culture.
Okay, what's the first one?
First was what they called political litigation. They specifically pointed to a pro bono lawsuit from 2021.
Pro bono. So free legal work.
Yeah, work done for the public good. In this case, it was a suit Paul Weiss filed for the D.C. Attorney General against people involved in the January 6th Capitol events.
Okay.
And the ECO made a point of mentioning the lawyer leading that case was a former partner, someone who'd been a top prosecutor for Robert Mueller. So drawing a direct line to politically sensitive work.
Interesting. So the government essentially flagged specific pro bono work as problematic. What was the second point?
The second one focused on personnel controversy. Specifically, the hiring of one attorney, Mark Pomerantz, in 2022.
Pomerantz, right? I remember that name. He was involved in the Manhattan DA's investigation.
Correct. And the EO didn't just mention his hiring. It made some pretty serious allegations. It claimed he'd only joined the DA's office to, quote, manufacture a prosecution against the president and had, quote, unethically led witnesses.
Wow. So not just scrutinizing the legal work, but individual hiring decisions and alleging past misconduct by that hire.
Exactly. It sent a message that who you hire and their background could suddenly become a federal issue.
Okay, and the third point. You said this one might hit closest to home for a lot of businesses?
Yeah, I think so. The third grievance was about internal hiring policies. The order flat out accused Paul Weiss of engaging in unlawful discrimination through its diversity, equity, and inclusion DEI policies.
So they went straight at DEI.
Straight at it. The administration said these policies were discriminatory and needed to end, and used that as part of the justification for sanctions against the entire firm.
Okay, so those are the justifications. Now, the sanctions themselves, this wasn't just a slap on the wrist, was it? This was designed to inflict immediate pain.
Oh, absolutely. These weren't warnings. They were immediate, operational, potentially crippling actions. The leverage was built into the speed and severity.
Let's break them down. What was the first major action?
Section 2A hit security clearances. The order mandated the Attorney General, the DNI, basically all relevant agencies, to immediately suspend active security clearances held by anyone at Paul Weiss and Pomerantz specifically.
Immediately suspend. For a firm like Paul Weiss, handling potentially sensitive corporate deals, maybe government-related work, losing clearances is huge.
It's potentially catastrophic. Overnight, you could lose the ability to serve major clients. It stops that part of the business dead in its tracks.
Okay, so clearance is gone. What else related to access?
Related to that, Section 2B targeted government facilities and services. Agencies were told to stop providing government resources, property services, and crucially, access to SCIFs.
SCIFs. Sensitive compartmented information facilities, those secure rooms you need for classified work.
Exactly. If you do any work related to national security, defense, intelligence, losing SCIF access means you literally cannot do the job. It's not just inconvenient, it makes you incapable.
So they're cutting off access to information and the physical places needed to handle it. That's quite the operational chokehold.
A very effective one. It goes beyond just hitting the bottom line. It hits the core ability to function for certain clients.
And then there was the hit to the bottom line, right? Section 3 on contracting.
Yep, the direct financial threat. This required government contractors, so companies working with the government, to report if they were using Paul Weiss for anything. And then agencies had to review those contracts and basically try to terminate them wherever Paul Weiss was involved as much as the law allowed. The message was clear. Federal money stops flowing to this firm.
So let's recap the pressure. Clearances suspended. Access to secure facilities denied. Active effort to terminate government-related contracts, all happening essentially overnight.
It's a multi-pronged immediate squeeze designed to force a reaction.
Which it apparently did. Because fast forward just 7 days, March 21st, 2025, a new executive order, 14244, comes out, and it just revokes the first one completely.
The whiplash is incredible. It basically says, problem solved, which means Paul Weiss must have agreed to some very significant things in that 1 week.
Okay, this is the core of it. What did they concede? The revocation order spells it out right. It calls it a remarkable change, of course.
It does. And there were 5 key commitments Paul Weiss made. They range from addressing the specific personnel issues to making fundamental changes in firm policy.
Let's go through them. What was the first concession? Did it relate to Pomerantz?
It did. First was an acknowledgement of wrongdoing. The firm had to publicly acknowledge the wrongdoing of Mark Pomerantz, addressing those specific allegations from the first DO, sort of a public mea culpa.
Okay, addressing the personnel issue.
Yep.
What about the political side, the January 6th litigation point?
That was covered by the second and third points. Second, the firm agreed to adopt a policy of political neutrality, both in choosing clients and in hiring attorneys. A major shift in stated posture.
Political neutrality. That sounds broad. How do you even measure that?
That's a fair question. But the commitment itself was key for the revocation, and it was tied to the third point, a massive pro bono commitment.
How massive?
The equivalent of $40 million in pro bono legal services pledged over the course of the presidential term.
$40 million.
Wow! And crucially, the order specifies where that pro bono work should go. Assisting veterans, promoting fairness in the justice system, combating anti-Semitism causes aligned with the administration's stated priorities.
So not just a general commitment, but directed pro bono work, almost like a mandated contribution.
You could certainly see it that way. It ties the firm's future public service work directly to the resolution.
Okay, so acknowledging wrongdoing, pledging neutrality, committing $40 million to specific causes. What else? There were 5, you said.
The fourth one is the one that probably has the biggest ripple effect for the business world, a fundamental shift in hiring policy.
This is the DEI part.
Exactly. The firm committed to implementing merit-based hiring, promotion, and retention practices. And the revocation order explicitly states this is instead of diversity, equity, and inclusion policies.
So a formal, documented agreement to replace DEI with merit-based systems as a condition for getting back in the government's good graces.
Precisely. It's right there in the text of the second executive order, a public trade-off. Change your internal hiring philosophy and the sanctions disappear.
Was there a 5th point?
The 5th point was essentially the overall agreement to undertake these remedial actions, which satisfied the concerns laid out in the first order leading to the revocation. The first 4 were the concrete actions.
Okay, so putting this all together, what are the big takeaways here, especially for people listening who might be in business or management or just trying to understand how Washington works now?
Well, the first takeaway is just the sheer power of policy leverage when it's deployed quickly and decisively. The government used tools it already had control over: clearances, facilities, contracts, to force massive changes inside a private company.
And they didn't need Congress or new laws. They used existing executive power.
Exactly, and the speed shows how potent that can be. The second big takeaway, especially for the business community, is that internal policies, like DEI hiring initiatives, are potentially on the table in these kinds of high-stakes negotiations with the government.
The commitment to swap DEI for merit-based hiring is now a documented outcome of executive pressure.
A very clear one. And you also have the explicit public agreement on political neutrality, the $40 million directed pro bono.
What?
These are significant concessions touching the core identity and operations of the firm.
So if you connect the dots, the initial order targeted specific legal work, a specific hire, and internal DEI policy.
Right.
And the resolution involved concessions directly addressing each of those points, neutrality on legal work, acknowledging the issue with the hire, and fundamentally changing the approach to hiring policy, plus a hefty financial commitment.
It was a very direct trade. You change these things we flagged, and the pressure comes off. The president even framed the resolution as giving hope that the legal profession would now focus on supporting communities, businesses, and families, linking the outcome to a desired change in the firm's orientation.
Which really underscores the policy goal achieved through this pressure campaign.
Absolutely. It wasn't just punitive, it was about reshaping the firm's behavior and policies going forward.
So, to sum it up, sanctions imposed, leveraging operational access clearances, SCIFs, and contracts. 7 days later, sanctions lifted in exchange for major policy changes, a neutrality pledge, and a $40 million commitment, all documented in official executive orders.
A remarkably fast and consequential sequence of events.
Which leads us to that final thought for you, our listener. We've seen how the government can use its immense power as a contractor and a grantor of security access to demand changes in a private law firm's internal hiring policies, specifically shifting from DEI to merit-based and its political neutrality.
So the question becomes, what does this precedent mean for other industries? Think about major consulting firms, defense contractors, big pharma, tech companies, anyone who relies heavily on government contracts or needs security clearances to operate.
If a powerful law firm's core policies can be effectively rewritten under pressure in just 1 week, what's the new landscape of compliance risk and potential government influence for your organization? That's something worth thinking about.